Megan Fox has the story.
Megan Fox.
Megan Fox.
Megan Fox.
Megan Fox. Megan Fox, a national journalist.
Mastodon. I will never be able to say that.
It feels like the Flintstones live there.
It does.
Well, don't trust women. I think you just touched on that with your last. That's what they brought. We're going to have to bring back chaperones.
Jesus, no.
Just careful. Stop! Right. Ooh. Hard right.
How did you screw up a stove, Megan? You're a woman. I thought that was baked into you, like at the genetic level, how to operate kitchen equipment.
And honestly, Megan, if you don't like it, I'm sorry. I've been very nice to you.
You get Dino hanging out outside chewing on a large bone. I highly recommend being targeted by the New York Times and Rolling Stone for weight loss. And I'd say, keep it coming. I need to lose 20 more. Please, keep it coming.
Explain to me, Megan, why did this country not have a holiday once a year? That's the time you vote. If you don't show up and vote, up your ass. You don't get another chance. You don't get, I don't care if you're in the hospital. Crawl to the stake, crawl there. But that's it, 1 day, 12 hours, and then you're done. And you count them that day, and that night you know who the hell won.
I will eat you alive. You want to tangle? You want to go?
The only thing going through my head is, what are you going to do when Megan Fox runs wild on you, brother?
He made a deal with the devil. She's the devil.
He wants that.
Oh, God. Gross! Oh! All right, penalty box for slug. Yep.
Of a mile.
Are you ready to behave yourself now, slug?
This frustrating rep.
Are you ready to behave yourself? Repossessed puppies. I'm hiding pork chop. ASAP. Have you seen his little pork chop? Oh my God, pork chop is the cutest.
That sounds bad.
Have you seen it?
Pork. It's pork.
Though you may be tempted, do not contact any person or persons mentioned on this stream. Do not even think about contacting anyone who may be the topic of the daily news. If you should do that, the host will question your IQ, possibly call you names, and mock you for disobeying these basic rules of decency.
All the best.
Good afternoon, everybody. Welcome back to the show. It's me, Megan Fox, and I'm here with Larry Forman, DUI guy. How you doing, Larry?
Hello. How are you? Long time no see.
I know. We haven't spoken since the Karen Reed verdict. Actually, that all happened after, since the last time we've spoken. That's been wild, huh?
Wild indeed.
It's good news anyway, because I was starting to get worried there for a minute.
Apparently, in speaking with Damon, the civil attorney that she hired to represent her on this.
Yeah.
I did the interview on my channel, and it was really, really unique to talk to him because he's like the unspoken, unsung hero. He's always there in the background. His face is there pretty much almost every day of court, but nobody knew his name. And yet, just because he wasn't front and center. So I gave him the spotlight. He agreed. And when we spoke, he was like, it's something, he said something that I have been thinking for a very long time. I was just too scared to say out loud because I felt like it would make me look like a fool, honestly. And here's what I mean. So he said, as the trial was progressing, he was convinced the jury is going to acquit. And given everything that we know and everything we know about life, everything we know about juries, everything we know about litigation and the case and the facts and then this and that, I agree with him, obviously, but I couldn't muster, I guess, I don't know if it's the courage or whatever it is. There's a level of something. I can't put my finger on it. Maybe Chad can help me out. But basically, you're sitting there and you're going, oh, she's going to get acquitted. I mean, come on. There's no way. What else is there?
Right.
You can't say it out loud. You know what I mean?
Right.
Because then you're like, oh, did I jinx it? Or, if something happens or like, and then you look stupid or whatever. But I don't know. What I felt comfortable with was predicting what the verdict is going to be. And according to my associate, I think I was one of the first ones who said.
I knew what it was going to be the second I heard the questions. No, the second the jury questions came back, it was like, oh, well.
Yeah, that solidified it for me too.
They're not thinking murder. They're thinking DUI. That's it. That's it. Driving under the influence. That's it.
Exactly.
Or whatever they call it there. Oh, you operating under the influence. Chad, I have turned up Larry's microphone. I know you're saying you're having a hard time hearing him. Let me turn mine down a little. Maybe that'll even us out. But I have turned it up. So I think it should be okay. Let me know. Oh, and by the way, Super Tips is not working today because I had a big update on my computer and then all my settings went out the window. And Brad, how dare he not be available for me at my beck and call, but he is not available to come and fix this right now because he's, I don't know, doing family things on a Sunday. How dare he, really? But he cannot fix it right now. So we can only do super chats today through YouTube. No super tips. Don't send super tips today, or send them and I'll read them. We'll do them tomorrow. But we can't do them today. They won't show up on the stream. And it's all Brad's fault. So blame Brad as usual. So the last time we were together, Larry, we were reading the JQC complaint, which is the Judicial Commission complaint for Judge Craig DeThomasis. And we had gotten to page 14. Now, those of you who want to see part 1, obviously don't go do that right now. You can catch up. If you've missed part 1, it's not like you have to go back and watch it. You can watch this out of order because there's plenty of allegations in this thing that are wild. Okay. And we are going to start from page 14 today and finish up. The part 1 is linked in the description of this video, by the way. Also, if you're watching on Rumble, hey, Rumble Ghetto, nice to see you. And if you have not subscribed to Larry Forman, you need to do that on his YouTube page, which is his YouTube channel, which is DUI Guy Plus. Actually, have you changed the name? You changed the name.
Well, it's Attorney Larry Forman. But it's still at the DUI Guy Plus. I don't know if I'll ever change that moniker because, come on, it's OG.
Right. It's OG. I agree. I don't think you should change it. So if you haven't subscribed over there on Larry's channel, make sure that you do that. So Larry and I were going over this JQC complaint. And a JQC complaint is when a judge does something that violates judicial canons. You have the right as an attorney or a litigant to file a JQC complaint, which basically goes over all of these things. So we left off here. Judge DeThomasis intentionally misrepresents and distorts facts in the record.
Sounds so unlike him.
Yeah, so unlike him. So these relevant dates are from the hearing on, and those of you just catching up, this would be from the Preston v. Hales saga, where she had brought and tried to get an order of protection against Jeremy Hales. It went on for 11 months with a temporary injunction without an evidentiary hearing, which is part of the complaint.
By the way, sorry to interrupt. Did you hear? I just remembered this. I don't know. I forgot to share this with you. Apparently, I heard Lynette is filing for bankruptcy.
Yes, that did just happen. Yes, she believes that she's going to get out of all of the lawsuits by filing Chapter 7. I want to say it's not 11. I think she filed Chapter 7 bankruptcy. I believe that they are incorrect. I do not think it will get them out of anything because defamation is considered a malicious tort. So you don't get out of it by bankruptcy. And also, you know what she hasn't considered, Larry? That Jeremy is one of her creditors. She owes him almost $2,000 in court costs for the Ohio injunction for being in contempt of court. She owes him attorney's fees.
Holy.
Yeah. So that means now that he's one of her creditors and he now has a right to enter her bankruptcy court case.
Careful how you phrase that. And nobody wants to be entering anything when it comes to Michelle Preston.
Okay, sorry, phrasing. Where's my button?
Phrasing.
True. But he does have a right to question and bring up things in that case, and I don't think that she considered that.
Yeah, no, definitely not.
Have you heard of this, of filing bankruptcy to get out of litigation?
Well, I've heard of bankruptcy to get out of debt. I mean, that's literally what bankruptcy is. When you have a mortgage and you have a car payment and you have a this and you have a that, and your source of income disappears or what have you, and now you can no longer pay your debts. You're not a Lannister who always pays their debts, You're the
Right.
antithesis. You're a somebody transliterate Lannister real quick backwards. Renegalo.
I can't.
You're a renegalo.
Restaurant.
And that's what you do. You file for bankruptcy. But there's certain things that are not dischargeable in bankruptcy, such as student loan debt, judgments. By the way, if Jeremy gets judgments against her, those are not dischargeable in bankruptcy. I don't know what her move is. If I were a betting man, I think that it's just a move because somebody said it would be a good idea for her. She doesn't know what she's doing. She's following someone else's bad advice.
Oh, we know whose bad advice it is, because
BBB?
John Cook publicly thanked BBB for giving her that advice.
That's what I suspected. Yeah.
Yeah. Mm-hmm.
No, the man is a menace. I think we've all.
Oh yeah, there's a lot of things I need to catch you up on, actually.
Sure.
Regarding that, because it's been rough. Let's put it that way. All right. So here we go. The relevant dates were the 12/6 hearing, 1/23/24 hearing, 2/28/24 hearing, and in his written order on 2/14/24 denying Hales' second motion to disqualify him. So Larry, you and I can take turns reading the pages here. Sure. If you can see it, okay. Otherwise,
yeah, I can see it. Mm-hmm.
Okay. Judge DeThomasis consistently misrepresented and or distorted facts in the record, usually to castigate or punish Hales' counsel and or protect Miss Preston or Mr. Silverman. Yeah, he did. He also misrepresented facts on the record to try to bolster his own conduct and give himself a judicial pat on the back. I love this. This conduct is particularly insidious because he is the judge, and therefore no one would question the veracity of his statements, nor even consider doing so. However, there were incidences where Judge DeThomasis was not truthful when recounting certain facts, and he used those misstatements to Mr. Hales' detriment and Miss Preston's benefit. By the way, this was written by Doreen Inkeles, who works for Shockett Law. She is a very good writer. I love reading her writing.
Yes.
Number one, misrepresented that Attorney Feather agreed to the December 6th as date for hearing to conclude. Judge DeThomasis misrepresented that Attorney Feather agreed to the second hearing date of December 6, 2023. Feather did not. The recording shows that Feather's back was to the judge when he announced the new date, and it is my understanding that Attorney Feather had not heard him. That's true. On the tape, you can see him. He's actually talking to Jeremy. They're consulting about dates and things, and his back is turned when the judge just announces it and then closes the hearing, goes off the record. Although Feather didn't object to the date, especially if he didn't hear it, to say he agreed to it was an outright lie. Judge DeThomasis used this misrepresentation as a bridge to launch even more condescending denigration and picayune, that's funny, picayune criticism against Hales' counsel and blame Hales' side of the case for delay in the proceedings when such was not the case. Hearings of 12/6, 123, and 228. All right, Larry, you want to read number 2?
Sure. Misrepresented that Attorney Feather stated on November 29th, 2023, that he could complete the whole case in 15 minutes. In some context or other, I see why you let me read this part now.
I wanted to hear you do 15 minutes.
In some context or other concerning the general issue of a continuance or a stay of proceedings, Judge DeThomasis constantly managed to segue into making irate remarks that attorney Mark Feather stated on November 29, 2023, that he could complete the case in 15 minutes, to the point where he became like a broken record, saying with constant remarks about Feather's purported misrepresentation and alleged violation of administrative orders. See unredacted recordings. The transcript, however, shows that Feather actually said he needed about 15 minutes to conduct Preston's cross-examination, not 15 minutes to finish the entire bloody case, you moron. Oh, I'm sorry, I added that language. That was not in there. These comments were also used as a segue into more uncalled for criticism at attorney Shockett and blame Hales' side of the case for why the case had gone on for so long. The case could not move forward, however, because Judge DeThomasis kept spending valuable hearing time criticizing, fault-finding, questioning motives, or otherwise going down rabbit holes that resulted in sudden ambush attacks on attorney Shockett instead of trying to get the merits of Ms. Preston's injunction petition. Even if, hypothetically speaking, attorney Feather had stated that he could complete Mr. Hales' side of the case in 15 minutes, so what? It's not a crime, nor is it unethical or unprofessional to underestimate the amount of time that it would be needed to complete a hearing. Judge DeThomasis, however, made it such a big deal that one purported statement, one would think Feather basically signed a guarantee or broke a solemn oath with Judge DeThomasis. Although Feather never appeared in court after November 29, 2023, Judge DeThomasis made it his personal mission. And he kept rubbing attorney Shockett's nose into what Feather allegedly did.
It's true.
Mm-hmm. Meanwhile, the judge's disproportionately accusatory and critical remarks were based on Judge DeThomas's factual distortions of what really occurred.
It became such a joke that every time, Judge DeThomasis would mention Mark Feather, we would all, Feather!
Yes.
Feather! Wait, Mark, 15 minutes! I mean, he just, every single hearing. And it's worth going back and watching those, folks. We have all these hearings. Both Legal Vices and I both watched them, sometimes together, sometimes separately. It is so good to watch them back because he was out of control. I'll take number 3. Misrepresented content of a memorandum of law. Oh, I remember this. To launch a disproportionate attack on Shockett and to protect attorney Silverman. This occurred at the January 23, 2024 hearing and in his order of 2/14/24. Oh, TX Jules says, my group turned it into a drinking game. We had to do a shot every time he said Feather. Yes. He was obsessed, absolutely obsessed. Context. Miss Preston was pro se until mid-January 2024. After she no-showed her first deposition on December 21st, 2023, thus causing the trial that was set for January 4th, 2024 to have to be continued, attorney Josh Silverman entered a limited appearance on her behalf on January 17th, 2024. The limited scope of his appearance was only to request a continuance of the trial, then set for January 26th, as he would be at the Marital and Family Law Certification Review course. Curiously, when scheduling final hearing earlier in January, attorney Shockett mentioned that he was slated to attend the cert review on 1/26. Judge DeThomasis nonetheless set the trial for that date anyway, yet the judge was willing to consider it good cause to accommodate a continuance of trial for Mr. Silverman to attend cert review. Oh, that's new. I didn't know this part. Did you know this, Larry?
Uh-uh.
Interesting. On the evening of January 16th, before he even filed his limited appearance, let alone a motion for protective order, Attorney Silverman informed Attorney Shockett by email that Ms. Preston retained him and that she would not be appearing for the conclusion of her deposition the next day, nor would Ms. Preston's witness, Mr. Cook, be appearing for his deposition set for 117, notwithstanding that Mr. Silverman was not even going to be representing Mr. Cook. Well, that's weird. How is Silverman allowed to say that Cook won't show up if he's not his lawyer?
Because might not.
It's weird. Once Silverman filed his notice of limited appearance, Judge DeThomasis set a short status hearing for the two attorneys on 1/18/24. Attorney Shockett hired a court reporter, but the judge made her leave. I didn't know this. He directed both attorneys to file whatever motions they wanted by 5 p.m. on Friday, January 19th, and set a hearing date of January 23rd for those motions to be heard. Although no order was reduced to writing from that proceeding, he still enforced compliance with his 5 p.m. directive for Hale's side of the case and ignored it from Mr. Silverman, who filed his motion over 3 hours late. Is this the same guy? Remember, he used to be like, at 5:55 and 41 seconds. You filed. Wow. Can a judge do that, Larry? Can a judge tell your court reporter to leave?
Yes, a judge can do anything and everything. They enjoy a enormous amount of protections. Like, that's one of the only times you hear the term absolute immunity. We've heard of qualified immunity with police officers. Absolute immunity means absolute. I know of only one instance in recorded history thus far that is top of mind for me, where a judge was successfully sued and had to pay $250,000 to the plaintiff in a 1983 action. This is a case actually had John Bryan. It's one of John Bryan's cases. He had a case. It was a domestic something or other. I can't remember. I think the couple was going through a divorce, and the guy had some of her stuff at his house or his stuff at hers. I don't remember. Anyway, the judge shows up on scene with the police, and I
remember this. She raided his house.
Yeah, she came over and raided the house. It was a divorce. Thank you, Chad.
Yeah, I remember this. I actually interviewed the lawyer who sued her, who was involved in the case.
John Bryan. No?
Yeah, I think, was that his
name? Civil rights lawyer.
The civil rights lawyer. Yeah.
Son of a gun. He's at like 1.3 million subscribers.
Is he? He should be. He deserves it. You know what? He
was at 300,000 like a year ago. He's flying. I'm so proud of him. Yeah,
that's awesome. No, he was a great interview, and that story was insane. And like it was all on camera. That's the funny part too. All the body cams from the cops that she was directing to like raid his house.
Yep. And he was like, "Excuse me, you need to leave." And she was like, "The hell I am." Well,
she was a riot.
That's a judge that has stripped herself.
Yeah.
Of absolute immunity, because immunity is absolute so long as, if you read the language of the statute, you are acting in the capacity in the furtherance of your duties in that position, like a prosecutor, like a judge. But the minute you step off, so anyway, you can get sued. The Thomases here, again, making a bad decision, making a bad call. Is it bad? Sure. But can you do anything about it? The answer is no, unfortunately.
Yeah, it's always no. The answer is always, unfortunately, no. I know of one other judge. I need to follow up on that case. Judge Eric Amy of Missouri. He's the one that jailed the Rocket children because he came off the bench, literally walked off the bench and escorted 2 children to holding cells underneath the court because they were refusing to go to their custody agreement with their mother. And he jailed them. himself personally.
What?
So he lost his immunity for that. And that lawsuit went forward. He did not, however, he jailed them twice. The second time he didn't lose his immunity because he issued an order to have it done across state lines, which was iffy. But because he issued it as an order, they said that he had immunity for that, which is still ridiculous because those two minors were strip searched and held in. Oh, it was horrific. It was horrific. A horrific case. Just because they were refusing to visit their mother and they were teenagers. You know, at some point, teenagers, they get the autonomy to say, I don't want to go with this parent anymore. And the judge just refused to recognize it. And the judge also was on the record basically telling their father, I don't like how you're raising them in Hollywood, and because they were performers, they're magicians. And he was basically saying, I don't think children should be in the entertainment industry. And that's why he kept ruling against their dad. Crazy, just crazy.
That's wild.
All right, at 5:22 p.m., I'm surprised she didn't put 5:22 and 13 seconds here. On 1/19, we filed slightly late a motion for sanctions, including involuntary dismissal against Ms. Preston, because at her deposition on 1/16/24, she repeatedly invoked the Fifth Amendment privilege against self-incrimination to virtually every question. Remember, she was holding up signs, I take the fifth, even though she was the petitioner seeking affirmative relief from the court in a civil matter. The motion contained excerpts of her deposition, so the judge could see from the transcript itself what she did. On the last page of the motion, there was an introductory paragraph for an accompanying memorandum of law with a notation stating that a case law analysis would be furnished prior to the 123 hearing, but the 5 p.m. time constraint did not allow for its completion. At 6:55, on 122, we filed and served the memorandum of law supporting our motion. Like any memorandum of law, it contained argument and cites to support precedent based on the factual information contained in the sanction motion filed on 119. The memorandum of law consisted of 11 pages, with the first 8 devoted to Ms. Preston's discovery misconduct in invoking the Fifth Amendment privilege, where she was the one seeking relief, as well as her failure to appear at her initial deposition for the conclusion of it after being rescheduled. The last 3 pages were primarily devoted to taking issue with Mr. Silverman's conduct in having halted both depositions arbitrarily, particularly as trial was set at that point for January 26, 2024, although a few sentences were devoted to Mr. Silverman's request for a continuance, not constituting good cause, at least not based on what Judge DeThomasis previously said. That issue was by no means the reason that we sought sanctions. Judge DeThomasis, however, misrepresented and mischaracterized the content of the memorandum, making it appear by omission of material fact that it merely complained about Silverman's request for a continuance, and then used that blatant mischaracterization to attack Hales' attorney and protect attorney Silverman. You want to take the next part, Larry? This one seems long. The judge's misrepresentation by omission.
Sure. The judge's misrepresentation by omission. The judge began the January 23rd, 2024 hearing with gratuitous insults and over-the-top criticisms. You don't say. Including calling it a, quote memorandum of law, unquote. Really? He then misrepresented the content of it to make it appear as if we were pursuing sanctions merely because Silverman requested a continuance of the final trial, when that was not the case, and it was obvious from the memorandum what the gravamen was. Judge DeThomasis, however, proceeded to take verbal pot shots at attorney Shockett, using the memorandum as a vehicle to do so, by making it look like we were being unreasonable over a mere request for a continuance. This, in turn, allowed the judge to launch into yet another history of continuances of final hearing that occurred in the case since November 29th, 2023, for which he blamed Mr. Hales and his attorneys, as per usual. By failing to mention anything about the discovery obstruction, the judge also kept his friend and/or longtime colleague, Mr. Silverman, protected from possible discovery sanctions. In paragraph 7F of Judge DeThomas's improper order of February 14th, 2024, Valentine's Day, by the way, denying Mr. Hales' second motion to disqualify for bias, he reiterates his disparaging remarks about the memorandum itself while continuing to misrepresent and mischaracterize the contents of the memorandum, stating, "It is true, as alleged in the motion under review on January 23rd, 2024, the court also commented upon a proffered quote-unquote memorandum of law that was presented to the court by attorney Randall Shockett, submitted on January 22nd in the docket entry 97, that, in the court's view, unnecessarily, unprofessionally, and gratuitously criticized opposing counsel for filing a limited notice of appearance for the purpose of advancing argument to continue on behalf of the petitioner, as counsel averred he had a conflict and could not and would not be able to serve as counsel in the event the court did not change the next scheduled hearing date from January 26, 2024, date previously scheduled." As the record would then indicate, the court did admonish respondents' counsel for presenting such an argument in such a manner, as the court also remarked and reminded Mr. Shockett that he, Mr. Shockett, filed his own notice of appearance 24 hours prior to an already scheduled hearing date scheduled for December 6, 2023. And as a result, he advanced argument that he could not possibly be prepared and thus required a continuance, which was granted. The rhetorical and condescending language advanced in a filing labeled as memorandum of law and which described as wholly unacceptable behavior of opposing counsel was, in fact, the same behavior previously exhibited by respondents' counsel.
God, he was such a blowhard.
Oh, I don't miss this man. Judge DeThomas's omitted material facts. Thus, you know, I miss DeThomas's like I miss having a cold.
I kind of do miss him though, because there were times I wish they really need to put a camera in his courtroom all the time. I would love to just sit in on some of his cases just to see how he's behaving recently, because sometimes he would do things that would just. It was so entertaining. I mean, not for the people in front of him, of course, but for the rest of us, it was like, oh my God, this guy. Mm-hmm. I kind of miss that. I miss how exciting it was.
Judge DeThomas's omitted material facts, thus distorting and misrepresenting the content of the memorandum. So, on the record, he misrepresented factual information contained in the record. Moreover, the judge then used those lies as more reason to chastise and belittle Attorney Shockett, who presented it, even though I wrote it.
Judge DeThomasis cherry picks language from procedural rules and employs double standards to favor or prejudice one side, not faithful to the law. 1. Cherry picks precedent in order to craft his lengthy, excessive orders denying our disqualification motions, which are required by rule to be bare bones. The judge marshaled old cases from the 5th DCA, which specifically conflict with controlling 1st DCA precedent, to make it seem like he had the authority to comment on the status of the record. See order. Yeah, I don't remember this. Do you remember this?
Yeah. I forgot about this. But, well, I remember he was his nickname was Cherry Picker. Remember, we even had
that's
AI.
True.
There's a reason why we came up with it. I forgot about it.
See order denying third motion to disqualify rendered 2/28/24. Cherry picks language from administrative rules. In his order of February 14th, 2024, denying Hales' second motion to disqualify, Judge DeThomas is quoted from Rule 2.330H, but he intentionally omitted the one sentence in the rule which prohibited him from writing his excessive order. I remember that. Mm-hmm. It is ironic that Judge DeThomas has violated an administrative rule, i.e. 2.330H, in order to belittle Attorney Mark Feather for violating an administrative rule regarding obtaining redacted versus unredacted audio-video recordings of proceedings. I remember that. Mm-hmm. That was funny. Cherry picks language from discovery rules. At the January 23rd, 2024 hearing, the judge intentionally omitted reading certain language from a discovery rule, which improperly caused a burden shift to Mr. Hales to show why Ms. Preston's deposition should be concluded when burden should have been on her to show why she should not have to finish her deposition. As this hearing was not noticed for discovery issues, Attorney Shockett was especially disadvantaged by not having his own rule book with him. However, one should be able to count on a judge to correctly recite the language from a rule. That's a very good point.
Exactly.
Yes.
I agree.
You should absolutely be able to count on the judge to be accurate about the rules. Employs double standards to favor or to prejudice. For example, at the January 23rd, 2024 hearing, Judge DeThomasis construed the concept of legal sufficiency leniently in Ms. Preston's favor to support maintaining the temporary injunction that he entered against Mr. Hales on 12/4/23, stating he was required as a matter of law to take everything she said is true in her supplemental affidavit and no choice but to enter the injunction, even though the factual allegations were a far cry from rising to that level to support an injunction. This was my argument the entire time. It was like, what evidence is there that this woman needs this?
Mm-hmm.
Meanwhile, when it came to Hales' disqualification motions, also reviewed for legal sufficiency, he did not apply the standard in similar fashion. If he had, we would not have had to seek a writ of prohibition. Larry, you want to take letter number 5? Not letter. What am I
Roman
saying?
numeral V.
Roman numeral 5. Yes.
I will read the V for you. All right. Double standards.
You almost made me spit my coffee out.
Not sorry for anything.
Damn it, Larry. Don't forget to hit that like button. There's 1,500 of you in here right now.
Oh, wow.
Hit that like. Yeah. Hit that like and subscribe. If you like the show, send breadsticks. We do like the breadstick money. Makes the haters mad. Makes them roll around on the floor crying, which is always something fun.
You know what I like to watch? I like to watch Megan roll around on her yoga mat while she reads things.
So does Bruce, by the way.
Well, isn't he married?
To a yoga teacher. So,
I
you know, I don't know.
Maybe he was
He's
taking
very
pointers from you.
obsessed. He's obsessed with that video. Get a hobby, Bruce.
Did you know that he went to Boston during verdict watch and he tried to DUI guy his way through?
I did. I saw that. I think he was looking for you. I think he was out there hoping to run
Thank
into
God I was
you.
in Switzerland.
Oh yeah, I saw that and I just LOL'd, and it was really funny because he kept trying to talk to people and nobody wanted to talk to him.
I know. And then he found like one person who finally like started speaking. I just kind of scrolled through it because I was curious what he's doing. And you could tell the people are just like, yeah, I don't want to talk to you, but sure, I'm getting airtime. I don't know how many people are going to see this, so I'll talk to you for a minute. And he'd just stay with that person for like half an hour. I'm like, who does that? You poor guy. Like not Bruce, but the guy who
the guy being interviewed. Yeah, right. You want to be on a live stream? We're live streaming. Like, well, where are you? To who? To how many people are watching this? There were like 60 people.
Yeah. Anyway, double standards across cases. When Attorney Feather asked on November 29th, 2023, for a bit more time past 5 p.m. to put on 2 short witnesses before adjourning for the day to avoid inconveniencing them, Judge DeThomasis let him know in no uncertain terms that keeping staff at the courthouse past 5 p.m. was not an option, and the proceeding come to a hard stop. Yet, in the companion complaint in Gosling versus Griffith, when Attorney Shockett let the judge know several times that he could not stay late because of an impending jury trial, Judge DeThomasis insisted on keeping the courthouse open until 8 p.m.
He did. It was insane.
Additionally, well, cherry picker. There it is again.
Yeah.
It's under the same heading. Additionally, even though Mr. Hales obtained a final order from an Ohio court granting him a stalking injunction against Ms. Preston after a full hearing when she appeared via Zoom, Judge DeThomas has refused to afford the Ohio injunction full faith and credit and therefore would not enforce it in Florida, which was really, really crappy, by the way. That's not proper at all. I was that's when I was like, I remember when I first came into this case, you know, a year and a half ago, and I was learning about all this stuff. And I was like, wait a minute. What do you mean? What is he doing? Like he has an injunction from Ohio. Enforce it. And they're like, but he's not. I'm like, what do you mean he's not enforcing? Like I couldn't register in my head. I was like, what do you mean a judge is not enforcing a foreign jurisdiction's order? It doesn't matter that it's in another state. You have to enforce it.
The Levy County Sheriff won't do it either. It's incredible. The Levy County Sheriff found no cause for any order violation in the 3 things that they did to get held in contempt in Ohio. So the same incidences in an Ohio court, the judge said, yes, they did violate the order, but Levy County said, no, they didn't. It's very upsetting to
and this is where
protective order, and they just won't uphold it.
Yeah, this is where judges, when they get it wrong, people can get hurt. I mean, luckily, Jeremy has like a big enough following to where he's in a way protected, you know, kind of. It's like a pseudo, like a cloak of protection, if you will. But what if he wasn't?
Yeah.
What then? And
I still think he's in danger, frankly, because the Levy County Sheriff won't take it seriously. He's already had a gun pulled on him 2 times. What's to stop them from really losing it someday? I mean, it's just all it takes is one time. And I don't know. I find it all very unhinged and scary for him. I've told him several times I would have left that place a long time ago.
Same. Yeah. Well, not right now. They're in Ohio while it's 107 in Florida.
Right.
Yeah. Okay. Where was I?
Right. It refused to afford the Ohio injunction full faith and credit.
Yet in another case, Mayas versus Arroyo, where Judge DeThomasis was the judge, Attorney Silverman represented the former husband and Attorney Feather represented the former wife. We have very similar facts in law, but a different outcome. Feather's client, who had been living in Puerto Rico, had tried to get a domestic violence injunction against her former husband in Puerto Rico and was denied. When Feather's client sought a domestic violence injunction against her former husband in Florida based on overlapping as well as new allegations, Judge DeThomasis stated that he had to give the order from Puerto Rico full faith and credit. And that's because her injunction was denied. Well, I'm going to deny it too and give it a full faith and credit. The recording of the Mayas proceeding from 2021 is available upon request.
I covered that on my channel. We watched it just to see him being completely different in another case.
Oh, yeah,
and it was, and again, he was ruling in favor of Silverman's client when opposite facts, you know?
Yeah.
The February 28th, 2024 hearing, although I extensively reviewed the recordings from the hearings numerous times in the course of drafting disqualification motions and the amended petition for writ of prohibition and related filings in Mr. Hales' case, I was present in person for the hearing on February 28th, 2024. That hearing was originally supposed to be for pretrial motions to be heard, as trial was set for March 1st. However, only our motion for stay pending filing a petition of writ of prohibition was heard because Judge DeThomasis had just denied our 3rd motion to disqualify that morning, and Attorney Shockett filed the motion for stay a few minutes later. Our motion for stay indicated that we now were going to be filing a petition for writ of prohibition in the first DCA, needed 7 days to draft and file it, and requested a stay of all trial court proceedings to allow us to do that and obtain ruling from the appellate court. I was present on 2/28 because Judge DeThomasis issued a scheduling order requiring all counsel to attend. However, the evidence shows that the judge was actually targeting attorney Mark Feather in particular to appear with Shockett. Specifically, an email from the judicial assistant sent on February 20th at 2:26 p.m. shows that Judge DeThomasis specifically wanted Mark Feather there, even though Feather had not appeared in court after November 29th, was not required to be in court after November 29th, and Attorney Shockett made all appearances as lead counsel after November 29th. The email from the JJA didn't say why the judge wanted Feather there. It just said including Mr. Feather. It was then expressly conveyed to the JA that Feather had to appear somewhere else for a client on a DUI matter on 2/28 at 3:30. The judge nonetheless issued a scheduling order on February 20th stating the hearing would occur on February 28th, 2024, immediately following the regular domestic violence docket beginning at 1 p.m., exactly when Feather could not be there, further stating at the bottom, all parties and all counsel must attend. Judge DeThomasis, therefore, intentionally created conflict and difficulty for Attorney Feather by ordering him to be present on 2/28 in Mr. Hales' case, knowing that Feather had a client conflict at the time and could not be in 2 places at once. The fact is, there was absolutely no reason for Feather or any other attorney, apart from Randall Shockett for that matter, to be present in court on 2/28, and Mr. Hales' belief in Judge DeThomasis easily could have issued his scheduling order without the extra command that all counsel must attend. But he didn't. Attorney Feather withdrew as co-counsel from Mr. Hales' case a few days later. At the hearing itself, Judge DeThomasis displayed improper conduct similar to that displayed at prior hearings, suddenly becoming irate for no apparent reason, raising his voice in an accusatory manner, making condescending and sarcastic comments in a tone of voice equally condescending and sarcastic. He was also doing a lot of hand motions. In his arrogance, he even stated that he did not believe a writ of prohibition removing him from the case would come to fruition, which is also improper commentary on the disqualification motion itself. His grudge against Attorney Feather was manifest with more comments about the same 3 prior issues. He misrepresented facts in the record a couple of times, interrupted Attorney Shockett but not Attorney Silverman, etc., etc. The recording submitted on the flash drive clearly captures all of that. However, a new pattern of misconduct by Judge DeThomasis emerged on February 28th, 2024, which I want to focus on because it is insidious and dangerous. Gaslighting. I'll let you start. Take this one.
I get the best part. Sweet. Okay. Let's see how much similarities he has with Hank Brennan now that I'm familiar with that scumbag.
Oh, God, Brennan was the worst.
The holes in the jacket when he brought my brain skipped a beat. I didn't even understand what I just heard. I was like, wait, he couldn't have possibly said that. Wait, he did say it.
Oh yeah.
Are you serious? Like my brain short-circuited. Like you don't like as a lawyer, you know, you got your civilian brain, you got your lawyer brain, and they're both kind of working simultaneously. And they were both like trying to figure out, what did I just hear? And by the time I figured it out, I was like, oh dear God.
He had to have known when he
Of course
said
he
that.
knew. 100%.
He had to have known. And he really thought he was going to get away with it, that the defense wasn't going to call that out.
Well, he was just
Amazing.
hoping to scramble the jurors' brains. That's his only chance at success, is gaslighting them into submission.
And for those of you in the chat who didn't watch that case, he basically held up a hoodie, John O'Keefe's hoodie, the murder victim's hoodie, showed these 3 holes in the back or big slashes in the back of it, asking the witness if he knew how those holes got into the hoodie. And the witness said, no, he didn't. Well, we knew how they got there. It was the medical examiner who made the cut, right? Medical examiner who cut his hoodie.
Hartnett. Her name is Hartnett. Maureen
She cut
Hartnett.
it, and the state knew that she cut it. It had nothing to do with the accident or the incident or the murder or whatever. Nothing to do with it. Those marks were put there by the state, and he knew that, and he said it anyway. Terrible.
Yeah. All right. Let's have some fun. Gaslighting as a point of common reference. Gaslighting is a form of psychological manipulation that hinges on creating self-doubt and generally comes from someone in a position of power. It's making someone feel unstable, irrational, and not credible, making them feel like they're seeing or experiencing isn't real, that they're making it up, and that no one else will believe them. Definition can be found at Forbes Health. See link below. Using excerpts from February 28th transcript, I will provide specific examples, some of which may overlap with other acts of identified misconduct also discussed. Mr. Shockett, a petition for writ of prohibition is being prepared. It's not quite ready yet. And actually, do you want to be?
Yeah,
Shockett?
I'll be Shockett. You be the court. A petition for writ of prohibition is being prepared. It's not quite ready yet, and the rules allow this. The cases allow us to advise the court ahead of time when there's such imminence coming with the first. So that's what we did in the exercise of caution. Mr. Silverman has agreed to it as well with continuing the TRO.
Well, there may be some consensus, but I want to hear from both counsel as to why the court should exercise discretion. I don't know the definition of discretion. I've never heard of it. Because its style is a motion to stay, which which is proper nomenclature to use, but effectively is also a motion to continue and delay my proceedings, which I'm not happy with and unacceptable in my courtroom, and I am the totalitarian. Anyway, moving on, I'm a judge. And the totality of the circumstances would include, at a minimum, that the respondent has been represented by counsel for 3.5 months. For more than 2.5 of those months, he's been represented by 3 separate attorneys. Unacceptable. You are not allowed to fire nor hire attorneys in my courtroom. 2 within the same law group. Why? One from a specific law group, and that has asked for a continuance, and it has been granted. A continuance on November 29th, December 1st, December 5th, January 4th, and now here we are again on a 5th motion to continue on behalf of the respondent. While at the same time, the pleadings include the history which complains about the delays of the proceedings, among other things. It's kind of inconsistent with what I'm asking, in effect, for another continuance. And so I want...
That was very good. It's very good.
I'm trying, Your Honor. I'm trying. You're Michael Lane.
Oh, sorry, chat. Yeah, if you're just getting here, super tips are broken, and it's all Brad's fault. Blame Brad. I can't put them up on the screen today. I had a computer update issue, and Brad was out shopping or something with family and couldn't fix it for me. So there's nothing I can do about super tips today. So either send them and we'll read them tomorrow, or don't send them, send super chats instead. Super tips are so much fun. Larry, have you heard my super tips with the AI voices?
Yeah.
Oh, they're a crack up. All right, you can continue this one since you're doing the gaslighting here.
Sure. Note 1. Although Judge DeThomasis acknowledges that both sides agreed to indefinitely pausing the entire proceedings while we pursued a writ of prohibition with the first DCA, regardless of whether the pause was called a stay or a continuance, he still gratuitously continued to foment the adversarial atmosphere by making the attorneys argue for what he was going to grant anyway. Note 2. Despite asserting many times that he, quote, found good cause for the continuances, end quote, it was clear that Judge DeThomasis blamed Hales and his attorneys for them, including his passive-aggressive digs while reciting the history of the record according to Judge DeThomasis at the beginning of each and every hearing.
Oh, God, remember that? The recitation of the record? God, it was so... He would spend 12 to 15 minutes reciting the entire case history. I've never heard a judge do that ever in my life.
Yeah. Yep. Not to that extent. I mean, I've heard of a brief recitation of the facts, but like, yeah, DeThomasis is a special cat.
I do miss him, though. I do. It made me laugh so hard that I'm realizing I do miss him. I miss his shenanigans. God, funny.
The irony of it all. The objectively verifiable facts regarding these continuances, however, are A, Mr. Hales did not ask for a continuance of the November 29th hearing. It had to conclude on another day because Judge DeThomasis, acting like Preston's lawyer, conducted her direct examination and didn't finish. So more than half of the case was left to be heard by the end of the day on November 29th, 2023. Although Attorney Feather expressed that he and Hales were willing to stay later to finish, Judge DeThomasis insisted in an uncalled for, snarky, condescending tone and manner that staying past 5 p.m. was simply not an option because he had to let the staff leave.
Oh, we have a footnote.
We have a footnote. Contrast with the companion JQC complaint against Judge DeThomasis arising from Gosney versus Griffith, where this judge did the exact opposite a few months later, insisting that he would keep the courthouse open until 8 p.m., knowing that Attorney Shockett could not stay late that night. So, folks, you can see the motive behind Judge DeThomasis. It's like when Shockett says, "Listen, Judge, I actually can't stay. I have to dip." Is no, you are staying. You know, it's you got to reverse psychology with this guy, because then the next time or the previous time when he goes, you know, actually, we can stay past 5 p.m. Absolutely not. I'm not keeping my staff on past 5 p.m. Just
Imagine how much his staff must hate him because they know that's a lie. Look, they know they're there at his whim. Whenever he wants them to stay, they stay. And when he doesn't, they don't. So, I mean, imagine being the staff I'd be rolling my eyes sitting there listening to him say, I can't keep my staff past 5 p.m. And then he keeps them to 8 on another night.
I have a story about that, but this is not the time. Maybe I'll tell that some other time. But anyway, more than half the cases were left to be heard. Wait, I lost my place.
We were at letter B. The judge did not grant.
Yes. Wait, did I finish the footnote? Knowing that
Oh, no, you didn't.
Judge Thomas generally seems to enjoy creating conflict, making things difficult, and oppressing attorneys. Wholeheartedly agree. It's really disappointing that a man, like, basically in his courtroom, you have to reverse psychology him, I think. Like, every time you want something, just ask for the opposite. And
the opposite.
Yeah.
Well, but only if you're somebody he doesn't like. If
Yeah.
he likes you, then you can ask for what you want. So if you're Silverman, you can ask for what you want. But if you're Randy Shockett, you have to do that. You have to reverse him because he doesn't want to give Randy Shockett anything that he wants.
Yeah.
That's bizarre. So if you're one of the judge's favorites, you act one way. And if you're not, you have to act a different way.
And how do you figure out if you're the favorite or not? You have to show up.
I don't know. How do you figure? It's not too hard. Just you can figure it out by the one he's yelling at.
Well, showing up is fairly easy unless your name is Bruce.
True. Also true.
The judge did not grant a continuance of Feather's December 1st motion. He denied it. Added to that denial, a surprise command for Mr. Hales to produce of his Ohio trip, violating his due process, etc., and then belittled Feather behind his back about his motion on 12-6. C. Although Shockett did file a motion to continue the 12-6 hearing because he came into the case on 12-5, on December 6 hearing, the December 6 hearing had to be continued as a matter of fundamental due process because Mr. Hales had just been served in open court that day on 12-6 with a temporary injunction, which the judge entered just 2 days earlier, based on Preston's supplemental affidavit of 12-4 naming Mark Feather. Speaking of, do you remember, I'm like, there is no way that he went through 306 pages or however long it was in like a day. What I think happened with the Thomases is when she initially filed Preston, when Preston initially filed her motion for, injunction, whatever, from Jeremy, he was just like, okay, let's schedule a hearing. Let's do this. Let's do that. And then she files like her thesis with the court. And
which made no sense. It was just rambling nonsense. There was no evidence in it. I went through the whole
threatening. Yeah, me too. I remember back in the day, but like, it looked very threatening. And so he was like, you know what? I need to err on the side of caution. So I'm just going to go ahead and, grant it. Anyway, moving on. It's like, wait, hold on. Just because it looks threatening, because there's so many pages that you don't feel like reading, come on, you can't do that as a judge. That's just not proper.
I personally think the moment he decided that Jeremy Hales was getting an injunction was when he heard him singing the song. He got personally affronted by it. He didn't find it entertaining. You remember there's a hole in Turtle Purgatory or something at the Turtle Farm? That one. She played that in court. And he is the kind of person who does not find humor. He doesn't understand humor. And he just decided to hate Jeremy Hales at that moment. His entire demeanor changed after he heard that song, which is so stupid because it was a silly song. It was just a silly little song that Jeremy made up about the turtle farm. And the judge just hated him. He just hated him from that moment. It was Robert Tower said it wasn't Jeremy's best song. That's funny. But I remember watching his demeanor change at that moment, and he just decided this guy's the bad guy.
Yeah. I mean, it's wrong, but I can see why.
Yeah. It is wrong, especially because he didn't take into consideration any of the actual evidence, and that particular song was not evidence of anything other than a guy in a dispute with his neighbors who made up a song. That's not illegal. It is not illegal to write satirical songs about your neighbors. Okay, that's not harassment. It isn't anything of the kind. A satirical song that would get laughed out of most courtrooms.
Yeah.
But not DeThomasis.
Not DeThomasis. D. Although we filed the motion to continue on January 4th trial, although we filed the motion to continue the January 4th trial, it was because Preston and her witness failed to appear for their depositions, i.e. discovery misconduct. Judge DeThomasis's obvious and often stated resentment over the fact that the November 29th hearing didn't conclude on November 30th caused him to continually and improperly question Mr. Hale's motives in this litigation and to impact nefarious motives to him, done on 12/6 and 2/28. Note 3. By first distorting the reasons that so many continuances were required and taking prior arguments about delays caused by Ms. Preston out of context, the judge begins gaslighting at line 23. He suggests, as if incredulous, that Mr. Hales and his attorneys are not credible and their motives for asking to pause proceedings should be questioned because they previously complained about the delay, yet here they are now asking for a 5th continuance, even feigning bewilderment at the purported inconsistency. He stated, quote, "I've got to question what is really the design and the desire, when it would be inconsistent to complain about the length of time and at the same time ask for a 5th continuance." Also rudely commenting, quote, "Then the other side of you guys' mouth is saying we need a 5th continuance?" The desire was to get Mr. Hales and his case away from a rogue and biased judge. Surprise, surprise. We weren't asking to continue the trial for lack of preparation or a sudden conflict. We were asking for a stay, whether you call it a stay or not, to have time for the appellate court to remove you from this case. And Judge DeThomasis knew this, having read and denied our 2 recent motions to disqualify him for bias, as well as the motion for stay itself. I have no idea why he tried to make it appear as if we were asking for a garden variety continuance having nothing to do with anything, with his own inappropriate prejudicial conduct, or why he feigned incredulity the way that he did. Judges should not gaslight, nonetheless. Judge DeThomasis engaged in more gaslighting by misrepresenting the appellate rules regarding the timing for filing a petition for writ of prohibition to make it appear as if we were not serious about doing so, or to suggest that we have waived such an opportunity, which was not the case at all. You want to take it from here?
Sure. There was the first motion to disqualify on December 21st, order denying 12/26, no writ sought. There's a second motion to disqualify February 11th, order denying February 14th, no writ sought. Despite the order denying the disqualification and no writ sought, and despite the fact that the writ of prohibition is the recognized proper avenue for immediate review of whether or not disqualification is an appropriate remedy, additional motions were filed on February 16th, 2 on February 18th, 1 on February 27th, all on the behalf of the respondent. Additional requests by counsel for the respondent for hearing time, the court scheduling and the hearing time for today. From note 4, from the court's view, contrary to 9.1, which requires a writ to be filed timely to prevent further court action, and then 1 week prior to the hearings been set on the motions that were filed after the second order denying disqualification, counsel for the respondent files a third motion to disqualify, order issued today's date, February 28th. Now the motion to stay amounts to saying we plan in the future when we get to it because, and I'm not belittling the intervening other requirements that counsel has both with the court and outside of the court, but saying I'm going to get to it, but I need more time to get to it because I've got other more important things to do than my client's cause in this case. So let's continue it again. God, he's such an ass. It says that there's already been a ruling creating further grounds for disqualification. So another motion for disqualification is likely to come, or a writ. I don't know which, but you've had time to do each. The rules require it to be timely. Note 4. Arguing like an advocate, Judge DeThomasis tried to create the impression that because Hales' counsel filed substantive motions with the clerk of the court during the month of February, trial was still set for March 1st, that they either really weren't intent on pursuing a writ or they waived doing so because things were filed in the e-portal docket. Note 5, timely is not the legal standard for filing a petition for writ of prohibition. It is as soon as practicable and governed by reasonableness principles. This was just simply a blatant misrepresentation of the legal standard by the judge. Note 6. More gratuitous, condescending, insulting remarks that are clearly belittling, despite the judge saying he wasn't belittling and making himself, his court, the center of the universe. Oh, yeah, he totally did that. Note 7. Although Shockett explained the concept of preservation of error to Judge DeThomasis, he still didn't understand that his excessive, overwritten, disparaging order of February 14th, that would be the 8-page one, that was so funny, denying our second disqualification motion became an independent basis for disqualification, requiring us to present him with a third motion to disqualify to preserve the error. Nonetheless, the judge only just denied the third motion on the morning of February 28th, 4 hours before we had to appear before him in court. So for him to say, but you've had time to do each, a writ petition or another disqualification motion in the 3 or 4 hours between the denial of the motion and driving to Levy County Courthouse was flagrant gaslighting, for the record. Judge DeThomasis distorted the rules on timing, not only to have fodder to try to degrade Hales' attorneys, but also to create the appearance that they missed the timing window on filing for a writ petition when that simply was not true. Judge DeThomasis also intentionally oppressed counsel with a Hobson's choice. As stated, we filed our third motion to disqualify the judge on February 21st, 2024, rather than dispose of it within just a few days, as he had the first two motions. Judge DeThomasis did not rule on this motion for 7 days. I actually emailed the judicial assistant early in the morning of February 28th, stating we were scheduled to be in court later that afternoon, but had not yet received the ruling on the third disqualification motion, and we needed to know whether to go or not. A few minutes before 10 a.m., we received the order denying the third disqualification motion, and Attorney Shockett filed Hales' motion for stay a few minutes later, requesting 7 days to draft and file our petition for writ of prohibition. Although attorneys Shockett and Silverman already agreed to all terms regarding pausing the proceeding before even walking into court, Judge DeThomasis made them demonstrate good cause to do so anyway, then insisting he needed to be convinced that we would get our petition for writ of prohibition drafted and filed promptly. He required us to draft and file our petition for writ of prohibition by 6 a.m. morning, March 1st, or face trial before him at 9 a.m., which was unacceptable as far as we were concerned. In the 38 to 40 hours between leaving court on Wednesday afternoon, February 28th, and 6 a.m. on Friday, March 1st, I worked straight through with no sleep in order to meet the oppressive deadline. I did have to amend it in part because there were incomplete sentences and incomplete thoughts caused by sheer sleep deprivation. There was no reason for Judge DeThomasis to put us under that kind of pressure. And there is a footnote. Compare with similar treatment of Shockett on 412 in Gosney v. Griffith. Oh yeah, in that one, he made him write the thing in 15 minutes, 15-minute break. He made him write it. We were joking that it was like he would have to go into the bathroom and get some paper towels to write it on because he was forcing him to do it immediately. I've never, it was crazy. Mr. Hales agreed to keep the temporary injunction against him in place during this process, and we would have honored the 7-day deadline we requested for ourselves. Judge DeThomasis was simply being oppressive for the sake of being oppressive, and his misconduct throughout this case was consistent therewith. You want to take 6?
Sure. Miscellaneous. Towards the end of the February 28th hearing, while discussing that Mr. Hales agreed to terms about keeping the temporary injunction in place while his attorneys pursued a petition for writ of prohibition, it was mentioned that Mr. Hales had recently been assaulted at a local restaurant by the son of a woman who served as the victim's advocate for domestic violence victims in Levy County. As Attorney Shockett mentioned that information to the judge, Mr. Hales pointed at himself with both hands as if to say, I'm the one with the TRO entered against me, but I'm the one who was attacked. Judge DeThomasis insisted that Mr. Hales was making a face and laughing when that was not true. I was sitting next to Mr. Hales at counsel table, stating that Mr. Hales did those things appeared to be more gaslighting on the judge's part, just to give him false appearance that Mr. Hales was disrespectful to the court and basically give him a bad name.
Mm-hmm.
Additionally, in this, because it's easier to attack him then, because if
Right.
he's misbehaving in my courtroom, I can now use him as a target, lightning rod, you know?
Well, and in the Gosney v. Griffith case, he screamed at Mr. Gosney about, do you have a recording device on the table? Is that a recording device? It was the man's sunglasses that the light was reflecting off of. And he did that. It was the same sort of thing. And in fact, he had done it because of the Hales case. He was like, well, I've had a previous case where this was a problem. But that wasn't a problem in that case. That's the other thing. Like, he's just making it up. Jeremy Hales never recorded anything in court.
And, from people who have seen the Thomases in the flesh, in the wild, at like bar functions and things like that, I hear he's a really, really fun guy to talk to. Like, he can be really funny and, whatever. Sometimes he'll give you like the cold shoulder if he doesn't like you. But even if you're like meh with him, from what I hear, he's a very
he's very charismatic.
Yeah, he's got charisma
very
for days.
charismatic. The thing is, and that's how he got his appointment too, being very charismatic with the governor. The thing is, only the best psychopaths are charismatic. like Ted Bundy, for instance. If you really look at it, all the most famous psychopaths are extremely charismatic. So that charisma doesn't really tell you anything about someone being a good person or not.
That is very true. I mean, look at me. Anyway, moving on. Additionally, in this context, I believe the commission should investigate any and all communications Judge DeThomasis had or may have had with victims advocate Amanda Martin during the course of this case. Judge DeThomasis professed lack of knowledge about the assault on Mr. Hales by Ms. Martin's son simply did not seem genuine. Moreover, Judge DeThomasis' entry of 2 sua sponte ex parte orders on December 6th and January 16th to preserve the camera footage of the courthouse parking lot based on quote-unquote advised or quote-unquote informed by someone that there could be relevant footage there was likewise strange, considering that Judge DeThomasis has violated so many canons of judicial conduct with impunity and repeatedly. It is not far-fetched to suspect that he may have been engaging in ex parte communications with the victim's advocate of the courthouse whose adult son assaulted Mr. Hales. For the 6 months he presided over Mr. Hales' case, Judge DeThomasis repeatedly abused his power as a judge and violated the Code of Judicial Conduct on many levels. Some more insidious than others. Some more insidious than others. I believe that in this case alone, he has demonstrated a complete lack of fitness to serve on the bench. I have spoken with a few other lawyers locally who have encountered similar behavior from this judge and will not take cases in Levy County if they know that Judge DeThomasis is going to be assigned, myself included. I hope the commission will thoroughly investigate the issues raised herein and discipline Judge DeThomasis accordingly, including recommending removal from the bench entirely.
So that would be the end of the complaint. We don't really know what happened. We think that we know that the complaint itself was dismissed, right? So they dismissed the complaint, but that doesn't mean that some action wasn't taken. Like, for instance, he could have received a letter of warning, which I think is probably what happened, because sources inside the courtroom who have been in front of him since say he is a changed man, that he is not doing any of that stuff anymore, that he is acting very reserved.
I wonder if that's true.
Well, that's what they're saying. That's what people who are in front of him are now saying.
That's a good thing. That means it's working. It worked. The JQC thing and making him public and all that, mission accomplished. I will take it.
Right. Well, that's why you can't get too upset, chat, that it got dismissed, because for one, it was the first complaint that we know of against him, and usually they don't act on a first complaint, but they would perhaps send a letter of warning, or basically saying, hey, shape up, but they wouldn't take you off the bench for a first complaint.
No.
However, he's on notice now. If there are more complaints, if he continues this behavior, and then there are more complaints, it will lead to a hearing, and it would be a public one, by the way. It would be a public hearing. So, I think what happened here is I think the JQC reached out to him with probably a letter of warning, and he has been a changed man ever since. We have heard no more complaints about Judge DeThomasis. And also, one person in the courtroom actually said he has stopped doing that thing where he recites the entire case history, and he has started to just say, counsel your motion.
No way.
Wow. And that lawyers have noticed that he is being very careful now with his commentary. Let's just put it that way. He is doing much less commentary, which that's really good. And we should all be very, nobody wants to see a judge get removed if the behavior can be corrected, right?
Sure.
Yeah.
So I'm all for it. I love this.
Yeah. My sources inside the Levy County Courthouse say that he is a changed man. He is very, he's much quieter. He does not interject himself into cases like he used to. And he's much humbled.
Huh. Humbled Thomasis. Very, very interesting.
Yeah. So it is very interesting. Very, very interesting. So tell me, Larry, I'm gonna hit some super chats. You are welcome to stay if you want to stay. Otherwise, you can get going if you need to.
I appreciate that.
You're gonna stick around?
Yeah, I'll stick around for a little bit.
All right, let's see. Caroline B, thanks for the 5. The crazy updates by Megan, but brings the facts. Well, we try. Love your Muppet avatar, by the way, Caroline. So funny. I have my favorites. Thanks for the 2. Hair looks great, Megan. Well, thank you very much. Today was not a wash day, so I was not busy drying my hair. So that's why the show started on time. And also Larry's here. So I appreciate his time and don't want to make him wait around because Larry's a tough guy to get a hold of. He's very busy. Sister Sal, well, you have a whole thing going on. You have your law practice and your YouTube channel, and it's great when you can be here. But everybody's like, you should have Larry on more often. I'm like, Larry's always invited, but Larry's busy. Like Larry's a lot going on. Sister Sal became a YouTube member. Welcome to the Fox Den, Sister Sal. It's weird here, but you'll get used to it. Cynic in Chief, thanks for the 5. Why is Larry on every jury? That judge always says, Mr. Foreman, do you have a verdict?
I was just thinking that the other day when I was rewatching the clip of the foreman reading the Karen Reed verdict, and I'm like, Mr. Foreman, do you have a verdict? I'm like, wait, what am I doing? I'm not in the courtroom. I'm in Switzerland. What is she talking about?
You know
I'm
what?
too busy being a psychopath, Mad Dog Prash. Exactly.
I would love you to interview that foreman on that case. He was such an interesting character. The Karen Reed jury foreman.
Oh yeah. I have another surprise for my audience, but I can't call it a surprise yet because I don't have confirmation, but it's a potential future surprise. Unfortunately, it's not him, but it's someone really, really good. Like I'm getting some juicy interviews because people are like, Larry, you're really good at this stuff. And they're sending me people. They're like, you should talk to Larry because there's this Paula, she did, Juror 11.
Yeah. I saw her with you.
And mainstream media interviews. And she was like, oh God, here's another one. And then she was like, oh, wait a minute. Who is this guy? And then she talked to her husband and her husband was like, you have to go on his show. Are you kidding me? And she was like, okay, fine. I'll do one more.
Oh, she was fun. I liked hearing her interviewed. God, the Karen Reed haters are unhinged. The way they came after her, the jurors who spoke out, the foreman and Paula, really, I mean, it's unhinged.
Yeah.
The jury has spoken. Like back the hell off. I'm
Respect
just
it. Yeah. If she had been convicted,
so tired
I
of
would have
it.
respected them too. You just because you got the verdict you want, it doesn't mean you respect them because of that. You respect the jury because you respect the jury. Period. The end. There is no I don't know. I mean,
And when I find when a jury reaches a conclusion that I disagreed with, I don't usually blame the jury. It is usually because the judge or the evidence was not allowed in front of the jury. You know, how can a jury come to the right conclusion if they don't have all the evidence, or the evidence is suppressed that would have turned them?
Is it sad that I would blame the lawyers? Because being a lawyer myself, I'm like, look, and far be it from me. I mean, I can only say so much, but think about it. If you know your audience, you know your judge, you know the judge is going to deny this, and this, and you have very limited information which to go upon. Sure, you're married to the facts. You can't change the evidence. You can't change the facts, but you can change your strategy.
Yeah. Well, I do think that in the first Karen Reed trial, I do think that the mistrial was the fault of the defense attorneys. They did not hammer reasonable doubt enough. They did not spend the kind of time explaining to the jury what a reasonable doubt is and how much reasonable doubt there was in this case. And you could see that they fixed that in the second trial, because Alan Jackson's closing remarks hammered reasonable doubt, hammered it. You know, and that definitely got through to the jury, because when they were being interviewed, all of them were like, there was just too much reasonable doubt. I had too much reasonable doubt. I didn't know how he was killed. I didn't know if there was a car accident or not. Those things, that was so important. And I think if it had been done in the first trial, I think she would have been acquitted. But I don't think they spent enough time on it.
Well, I think I was with you up until that last statement. The reason they hung on the first case is because charge 2, operating a motor vehicle, like killing someone while
leaving the scene or something.
No, leaving the scene was 3. They acquitted on that. They were unanimous. But it was basically there was like OUI and murder, and it's one charge. And they're like, but we want the OUI, but we don't want the murders. So like half of them were like,
oh, it was in one charge. I see. That's why separating that out was such a big deal.
Exactly. That's when it was like, oh, you bleed out the OUI. Because here's the thing. Paula said this very interesting thing compared to the foreman. Paula said when Karen walked in, she looked at her and she was like, oh, she must have done something. I wonder what she did, which is normal. Every juror thinks, every human thinks like that. When you sit down next to the defense counsel, you know, but not the foreman. The foreman said from day 1. I have the video premiering in 3.5 hours or 2.5 hours. So you'll hear it on my channel.
Oh, cool.
I talk about all this stuff that I'm saying right now, this brand new video premiering. I say, look, I hear him talking about walking in, and the first thing he thinks is that woman is innocent until these 2 fuckers over there prove her guilty. And I'm just like, wow, that's amazing. Look at
that's a good juror.
Same jury, right? 2 people on the same jury and 2 completely different impressions.
That's a good juror. Right.
In another interview that I didn't get the clip in my video for today, but I remember he said, like, if that had been my house and a dead man has been found on my front lawn, my house would have been raided. My walls probably would have been stripped. You know, like they would have completely raided my house if that was John O'Keefe found on my front lawn. Why?
Absolutely. That was the thing that always got me was how do they not see the privilege that these cops got? If it were any one of us, our house would have been turned upside down if a dead body is found on the lawn. Are you kidding?
Mm-hmm.
And that was the one thing that should have made everybody go, yeah, there's something very hinky with this entire thing. And it's not good enough. They did a shitty investigation and it's not good enough to put someone in jail for. It's just not.
Exactly.
Yeah. I loved the jury foreman. I just loved him. And I think we would be in such a better state if all of our jurors had his philosophy, you know, that these 2 idiots from the state got to prove to me that this person did anything, because as of right now, she's innocent. And I wish that everybody went into these things like that. There are very few cases where it's like, okay, the evidence is completely against, like the evidence is self-sufficient. Like it's going to be a very tough case. Like in my opinion, the Cobberger case was never going to be, he was never going to be acquitted. That evidence, I am so tired. I am so tired of hearing people say that circumstantial evidence is somehow less important than physical or other evidence. People are convicted on circumstantial evidence all the time. Circumstantial evidence is a very valid form of evidence, and the circumstantial evidence surrounding the Cobberger and his guilt was overwhelming circumstantial evidence. And I didn't get it. There's like this whole movement online about Brian Cobberger is innocent and he's falsely accused, and I just didn't see it. I didn't see it at all.
You want to know something funny, Megan? I've never told this to anyone. I've never talked about this on stream, and let your audience be the first people to hear this from my lips. I'll break the seal here on something that I've been holding deep inside, and for better or for worse. You know, the Idaho 4 murders happened on November 2022. He got caught right after Christmas 22, and he's been incarcerated ever since. There were hearings in 23, 24, and 25. Don't ask me why exactly, but I had this little voice inside, because I know like Emily D. Baker was covering it. There were other people covering it. Everyone's been talking about it. They're like, Larry, you got to cover it. Larry. And usually when I get like three, I mean, you know, this is a big case, but something inside, and call it like a mixture of instinct and gut reaction, lawyerly experience. There was something about that case, something about it that I was like, subconsciously, I was like, this case is not going to go anywhere. This case, there's no way there's going to be a trial. And that's why I never investigated. I never really read about it. I never caught myself up on the facts. I didn't want to spend time on it. For some reason, every time I would have time for it, I would do something else. I found myself gravitating towards something else. I cannot explain it. And it's the truth. And then finally, you know, right when the day I came back from Switzerland and Sweden, where at the house, you know, it's like a Monday, Tuesday, I'm finishing up my Karen Reed stuff. I have a few more videos that I'm recording. And I'm like, all right, it's time to do. Oh, wait, he just pled.
Yep. I was pretty shocked. I was shocked that it happened because it seemed like it was going to trial. And I mean, it was getting closer and closer, but it was definitely, it had all the earmarks of the perfect time to plead out, because they had exhausted all of their attempts at getting the death penalty taken off the table. They exhausted all their attempts of, you know, getting his autism taken into account for sentencing and all this other stuff. And the judge had denied it all. And the third party culpability thing just got killed. And, you know, where else is there to go? There's DNA, you know, there's DNA on the knife sheath. And that was, I think, the hurdle that they weren't going to get over, plus the phone being turned off at the exact moment that the murders were happening, which, according to a bunch of people who, you know, cover a lot of cases, were like, that's not good evidence. I'm like, yeah, it kind of is. It really is good evidence. It's especially if it's unusual activity for your phone. If you do not normally turn your phone off between these certain hours, and suddenly just so happen to turn it off during the exact time you would be murdering someone in another town, that's evidence. And I did not see that as being overcomeable and if I were on that jury, nope, I'm seeing it as that is overwhelming evidence to me.
2 months ago, I had a case. Here are the facts. My guy was driving up or down 65, and this was in Hardin County. He wrecked. He had allegedly, quote unquote, been drinking. And he, destroyed his car, completely destroyed. He refuses the breath test, I believe, or blood test, whatever. They get a warrant. He refuses that as well. Basically, they have no chemical evidence. But my guy wasn't going to go testify. Otherwise, he would have been completely creamed. So we scheduled the case for trial, and I'm convinced that I can win. And it really was a good case to win, because they still have to prove his guilt, that he was under the influence. And accidents happen. They can't prove that he was drinking. It doesn't matter how guilty or innocent your client is. As a criminal defense attorney, all of that is irrelevant. It's all about what can the government prove and how can I defend against it. If I can, I will go for it. If not, then you plea out or maybe get an amendment if it's really bad case for the prosecution. This is how a criminal defense lawyer's mind works, okay? And there's a very famous case, one of my favorite cases, United States v. Wade, 1963, I think. We are not obligated to tell the truth. We have no duty to tell the truth, the whole truth, and nothing but the truth. We can't lie to the court, openly deceive the court, the jury, etc. No, that's a huge no-no. But lying and telling the full truth are two different things, right? So I was going to set the case for trial. I set it for trial, and I think, absolutely had a very strong chance at winning. 3 days before the jury trial, the prosecutor, he gets the hospital records. And in the hospital records, there is one statement, Megan and Chad, one statement that he makes to the nurse while he's at the hospital. And she just writes it down, Latin with typos, because she's, nurse typing, whatever. And it says, subject admitted into the hospital, no severe injuries, took blood. Oh, by the way, subject admitted that he had a little bit to drink, fell asleep behind the wheel of the car, caused the accident.
Oof.
What do you think I did? The next day I called the prosecutor and said, hey, bud, we're pleading guilty.
We're pleading. We're pleading.
It's the DNA. It's the smoking gun. I can't get around it. It's one phrase. It's a statement against interest. It's incriminating. The jury's going to look at it and go, well, he admitted it. So what are we doing?
He admitted it. Yeah. Yeah. And that's how I felt this case was. And I did not understand the rabid, these people who were so convinced that he did not do this. It didn't make any sense to me. It made no sense. I was like, this evidence is, and I wrote about it on PJ Media. When it happened, I wrote several articles, and I went back and read them, and I was like, was I misled? Because my articles were like, this was fantastic police work, and they got their guy. Like it was really good police work. They from the DNA swab on the Q-tip from his dad's garbage to the phone records. I mean, I thought it was great police work. And then all of a sudden there was all this movement about, they've got the wrong guy. And I'm like, what? How is it? If he's the wrong guy, he's the unluckiest MFer to ever walk the face of the planet, because everything stacks up in his guilt. Like it just does. So yeah. Well,
they went all the way to Pennsylvania to get the son of a gun,
And I think they were following him too. I mean, he got pulled over twice on that trip.
Really?
And I think they were just checking in on him. Yeah. He got pulled over for following too closely twice, which is a really strange thing to be pulled over for on the highway if it's legit,
Sure. Yeah.
It's just kind of a strange thing to be pulled over twice for. And then they had body cam footage of him and his dad in the car. And, I felt like the feds were probably tailing him and asking cops to, pull him over. But I don't know. That was never confirmed. That was just my feeling on it.
Sure.
I'm not sure if they were allowed to do that, but I think that's might have what happened. T. Underwood, thanks for the 5. Being on time reward. We love you on time or fashionably late. Also keep laughing. Yeah, I had this idiot leave a comment about how your laughing is so unprofessional. Just tell the story. And I was like, oh, I'm sorry. You must be looking for Law and Crime. That's not what I do here. I'm sorry. If you do not like people having a good time and enjoying laughing at stupid things, then you won't like it here. Cindy Brown, thanks to the 2. Level of confidence, Larry. I think this was in response to, I remember when this came in. Shoot, what were we talking about? I remember it had something to do with the attorneys in front of Judge Grudge.
But it's level of confidence, say.
I think that's a typo.
Oh, I was getting excited.
Confidence, say.
I was like, what does this mean? Level of confidence, say, Larry? Like, is that French? I don't speak French, but I want to know now.
And Rylan Poole, thanks for the 2. Just sent a super tip. No worries. Palms Come Posse. I'll read it. I'll have it read on another day. We have blame Brad. Okay. It's Brad's fault. Rozilla's Realm, thanks for the 5. If you're suffering from detomasitis, clean out your ears for a change. M169, thanks for the 5. Never stop the laughter. You have the best laugh. Screw the haters. Keep doing what you're doing. I love your work. Yeah, it's weird. People who criticize you on YouTube are often strange. They criticize really strange things. And I love highlighting those criticisms because they make me laugh.
If you guys like this kind of stuff, you're going to love my video tomorrow. You know the Jimmy Kimmel celebrities read mean tweets?
Oh, yeah. Love that.
I did DUI Guy Reads Mean Tweets about
I should do a series of those too. I should save up all my nasty comments. Just make a video of it. Don't forget, what time does your video today premiere?
4 p.m. Eastern. So
okay. I couldn't. Is
it
scheduled? Because I couldn't redirect for some reason. I was going to redirect, but I don't see it up there.
I appreciate you. I don't think it is.
Okay. But those of you, don't forget to go and watch that today at 4. Larry's got a new video coming out. Double Karma, thanks for the £5. LP filed for bankruptcy, yet still buying shaped stones. Yeah, so she files for bankruptcy, and then we've got her buying stones from the Lees on their show. Like, how is this a thing? You know, like, how are you bankrupt? But you're just spending money all over the place. Sean Poe, thanks for the 5. Larry, we need a little 15 minutes. Mark Feather, grumble, cough. We miss it. Love you.
15 minutes, Mark Feather!
Puzzled Puzzler, thanks for the 5. Dum Dum Ash got to be a judge on the merits of simply being alive. Man Bear Pig, thanks to the 5. Was Deducious getting salmonella gummers from LP or other things just as infested with said salmonella? Now that is just a rumor. God's sake. Rosalind Duke, thanks to the 5. My super tips fell down. Yes. Where's my button?
My child just fell down.
DJ Radis, thanks to the 2 for garlic breadsticks. It's time to get fancy. Puzzled Puzzler, thanks to the 2. T herds attacking feathers stick together. Herds attacking feathers stick together. That's funny. Becky Fear Wreck, a member for 5 months. This is so good. We miss Larry. I know everybody loves Larry. Everybody loves Larry. And Nowakowski, thanks to the 5. Hi, Megan and Larry.
Harry.
Harry.
Larry. Scary Harry.
Larry, whatever. Hi, Ann. It's good to see you. Emmy, thanks for the 10. Larry, your Judge Grudge is so perfect. I'm laughing so hard. It is really good. It is really good.
I'm glad you guys are enjoying it.
Palmer's Archer Homestead, member for 9 months. I love Larry's Judge Grudge impressions. Maybe not. Gifted 5 Megan Fox memberships. Oh, that's awesome. Thank you. And welcome, all 5 of you. Now that you're in, you can't get out. Don't even try. You won't be allowed. Jada, thanks for the 10. It scrambles my brain to look back at these dates and realize this mess is still ongoing for Jeremy and George. When in court will enough be enough? Guys, I am working on a new TLDR for this case where I am focused on the litigation alone and talking about how the litigation started in each case. And I was going through the Fed 1 case, the federal litigation, where the one just against John and Lynette. I am writing up a script to do an overview of Fed 1. It is outrageous what has been done in this case. And I have missed it because sometimes if you don't have a broad overview, you miss some things. Wait till this video comes out. You guys aren't going to believe how outrageous this case really has been. And I don't know when enough is enough. We're going to need a judge who's going to notice what's going on. And so far, we haven't got that. Mama Bear Leah, thanks for the Canadian too. Awesome hair day, Megan. You look beautiful today. Well, thank you so much. I love your Muppet. I like your Muppet's hair.
Canadian too? That's like $1.83 US. What the hell?
It'll do. I'm fine with it. I like how her hair looks like mine. I like it.
That's what drew my attention.
And look, here's another one. Great to see you, Larry. We miss you. 15 minutes.
Thank you.
Cynic in Chief, thanks for the 5. Now I get why LMNOP thinks she can ignore discovery and complain about Jeremy's comments. It worked for Judge Grudge. Why not for Bolitho? And actually, so far, it's kind of working for Bolitho. I mean, has he granted any sanctions against them for not turning in discovery? No, he hasn't. Is he going to? I don't know. I expect there to be more orders on the docket tomorrow. But the guy he's a paper tiger. He says he talks tough and then he doesn't do shit. Puzzled Puzzler, thanks for the 5. Both juries came to the same conclusions, essentially. Who is going to investigate who really did it? I don't know. I think the feds looked at it, but murder is not their jurisdiction. Their jurisdiction is overseeing other like in police and, if they need to look into a police investigation or something. But I don't know I don't think John O'Keefe's murder will ever be solved because it would be up to the Canton police or the Massachusetts State Police to do the investigating. And we all know that they're not interested in doing that. What do you think, Larry?
Well, I have said this before and I'll say it again for those of you who may not know my thoughts on this. The FBI, unfortunately, from a practical standpoint, they can't spend time on a case like this without an additional lead, because what do you do? What do you start calling these people in for questioning one by one? They're going to stick to their story. They've already proven that fact. They're looking for the weakest link. They're looking for, like, if there's anyone who would be willing to crack or whatever. What is going to happen now is, with the passage of time, they say time heals all wounds. One of these co-conspirators or one of their lackeys that knows stuff about it, family member, the young daughters of the McCabe's, you got Olivia and Allie and a couple others. One of them at some point somewhere is going to just accidentally blurt something out, or maybe like in a drunken fit. Like I always keep joking, that Brian Higgins is going to be in Aruba, on an island, just drinking himself stupid and getting into it with some random guy, and they're going to go into like who's got the biggest swinging dick contest, and Higgins is going to be like, "Oh yeah, well I killed a man and got away with it," like that's
right.
That's something like that.
That's what it would take.
Yeah. And then now all hell is going to break loose, because then it's going to be like, wait a minute, why did he say this?
I hope it'll be, if I were to guess, I would think it would be one of the kids who got roped into helping to cover it up. Like whoever took the dog out of the house. Who took the dog?
I think it was Higgins. I think they killed the dog on the
You
spot.
think Higgins took the dog? I think it had to have been one of the kids. I think it was Allie or Colin who took the dog.
No, it's too heavy for Allie. She can't carry. I mean, a German Shepherd of that size.
Wait, you think dead dog? You think it was dead? See, I think the dog was alive when they took the dog from the house. And I think that the dog was disposed of at a later date.
No.
But the dog went home with somebody.
They're scared because they don't know. What if the police are going to search tomorrow? Like tomorrow morning?
How did they kill the dog? Nobody.
I don't want to
would have heard you would have heard a gunshot. Somebody in the neighborhood would have heard a gunshot. So you're not shooting the dog.
I don't want to talk about it. I'm just saying. It's too I can't. It's too cringe.
I know
my whole body
awful.
just vibrates negatively when I even think about it. I can't.
I know it's awful, but I feel like the kids might be the weak links.
Yeah, I agree 100%. The kids are the weak links.
If they ever get mad at their mother, it could get bad. Carl Bethard became a YouTube member. Welcome to the Fox Den. It's weird.
I gotta get going, Megan. Sorry.
Go
I'm
ahead.
messaging you, but you're not reading, so I have to say.
Oh, I'm sorry. I'm not
No, you're
reading
good.
my
You're
messages.
good.
You head out. Thank you so much for being here. I appreciate it, Larry.
No, this is awesome. I really wanted to finish this now that I finally have a minute before I get busy again.
Yeah, I'm glad we did.
It was a lot of fun, and I'll tell Doreen to go check it out if you haven't already.
All right, definitely. I did. I let her know. So
okay, cool.
Yeah.
This is fun.
All right.
Thank you, chat. Thank you, Megan. We should definitely do something like this again in the future.
Oh, for sure. We really should go over the one about Gosney v. Griffith. It'll blow your mind.
Maybe. I'll be honest. I'm not too personally vested in it. Shall we say? My spidey sense is tingling elsewhere.
All right. Well, we'll figure something out.
Absolutely. That is no doubt.
All right. Take care.
All right, you guys. Bye, Chad. Bye, Megan. Thanks for having me.
All right. Let's see. Where are we at here? Rickles 64. Thanks for the 2. Love it when you two stream together. Well, so do I. It's always nice. And Larry is always busy, so it's great when we have a moment. And C became a YouTube member. Welcome to the Fox Den. It's weird in here, but you'll get used to it. Trust me, it won't hurt after a while. Frenchie's mom GB. Thanks for the 6. Thanks for bringing us all the way back to Grudge Judge. 15 minutes. Thanks for the laughs. And Dan Davis, thanks for the 5. He only sanctions the one guy who is following the law, Randy Shockett. Right. I don't get it. I do not get it. Terry Ham, member for 6 months. Thanks for being a member, Terry. Louis Moore, thanks for the 5. At the risk of being too late, picayune is pronounced picayune. It's a great word for fussy pickiness. I thought it was picayune, but I could be wrong. Picayune. Emmy, thanks for the 5. Larry, in your courts, are they this incompetent or is it just a Levy County thing? Oh, this is, I would say that, I think Larry has said this before. I can answer for him. He has a lot of good judges where he is. He has not seen this kind of thing. I think he only had one run-in with one judge once where he practices. And this is very unusual for any jurisdiction. Like it's very unusual to have a judge behave like this so openly. I mean, it really is. I can't name one who has been as bad as Judge Grudge. So openly horrible to everyone. Mama Bear Lee, thanks for the Canadian 5. I'll put tariffs on my $2 for you, Larry. Crystal Thomas, thanks for the 5. Why didn't Jen wonder if her sister and brother-in-law were dead in the house too and walked in without a thought? Yeah, I know. This never made sense to me either. You find a dead guy on the lawn of your sister's house. If you don't know that everybody inside is safe already because you know how that guy got there, you would be panicking and trying to make sure that everybody in the house was safe. You'd probably send cops into the house, right? But the idea that she didn't, it's weird. It's weird. All right. So thank you so much, everybody, for being here. That's the end of the Super Chats. And I just really appreciate you guys. Thanks for tuning in and for keeping up with this story. And make sure that you stay tuned for Larry's video premiering at 4 p.m. Eastern Standard Time today. I think Tug's probably going live tonight, too. He usually goes at, 6 o'clock before Jeremy goes live at 8. I am going to see the Beach Boys, so I'm taking off now, and I'm going to go have some fun with the family and have a fun concert in the park and watch the Beach Boys. That should be a great time, and I appreciate you guys. Let's see, what song should I leave you with? I feel like I should leave you with something. I don't have anything. Oh, I know what I'm going to leave you with. I'm going to leave you with my Otter Creek song. We haven't played this in a long time, but this one will relate to today. All right, everybody, take care.
Get on down to Otter Creek, where your problem seems small when you see the squall in Otter Creek. It's full of freaks, warring neighbors, angry gators, stolen trailers, and little people in the walls. Otter Creek truly has it all. Otter Creek, oh my, my. Otter Creek, it'll make you cry. Otter Creek, don't come on by. In Otter Creek, you just die. The cops turn a blind eye to all kinds of crimes. The prosecutor's lazy, they toss more than they try. If you get held up at gunpoint, don't bother calling it in. Nobody will pay for it, you just can't win. Otter Creek, oh my, my. Otter Creek, it'll make you cry. Otter Creek, don't come on by. In Otter Creek, you might just die.